But how you are going to proceed for that, I think Dr. OVAIS is the right person, because I'm not expert in it and I don't know much about it. I think you are lucky enough, you are knowing all these things at an early age. Even at this age, I may not be knowing all these things, but I hope this is going to benefit you in the long run. Thank you very much.
So the definition of the intellectual property rights was given by WIPO, World Intellectual Property Organization, which is handling all those things. The definition says these are the rights related to literary, artistic, and scientific work. That means if you write something, even if you click a photograph, that will also be considered as an intellectual property. So, performance of the artists, like you see the performances on your TV, that's also in creation, that's an intellectual property. Invention in human endeavor, if you design some drug, if you design something, some new car, new engine, that will be an intellectual property. It is lifetime of the author. That is, if I wrote a book, it is my lifetime, plus when I die, from next day it is 60 years. You have to count 60 years for that. Even for the photographs also. If today I click that photograph, the copyright will lie with me jab tak main zinda hu, and from next day it is 60 years. For all other works like cinema, sound recordings, posthumous publications, where after the death things have been published, it will be 60 years from the date of publication. Pseudonymous work, where you don't know who is the author, it will be 60 years from the date of publication. Anonymous work, where you don't know who is the writer, it will be 60 years from the date of publication. But somehow, if you come to know who is the publisher, it will be his lifetime, or who is the creator, it will be his lifetime. For ethical treatment of animals, they come into the play, they filed a case against David Slater that this picture belongs to this person, this chimpanzee, Naruto. The copyright lies with him, and you cannot publish this photograph. The court, although the court gave a decision in the favor of David Slater because copyright lies with the human beings, and they could not prove themselves as next friend, but still there was an outright court settlement. 75% of royalty of this photograph goes to the David Slater, and 25% goes to that wildlife sanctuary for its development. This is protected under trademark, we should not copy it. What is trademark? According to section 2ZB of Trademark Act, anything which can be represented graphically, it can be sign, it can be word, it can be a letter, combination of colors, it can be a shape of good, anything which can be represented graphically can be your trademark. For example, you have this mark, wool mark. You go to the market and buy a sweater. When you see this mark, you say that okay, its quality is good. Because wool mark, हमको यही पता है बचपन से कि this it has good quality. We should it is always a good quality thing. Yeah, we have Amazon. A to Z, niche arrow. This is a trademark of Amazon. This is trademark of Nike. Similarly, for Apple, Google is going to flourish. And nobody should copy it. It is better to have a trademark. So you file an application before the registrar of trademark in Controller General of Patent and Trademark office in Delhi or wherever you want to file it. If it is examined, if it is granted, you will get protection for 10 years. In copyright it was 60 years plus lifetime of author. Here it is 10 years and it can be renewed indefinitely. These are different types of trademarks. We have mark on